You ask more questions. Hi, Emily. I just want to cut the crap and let's go to the topic.
All right.
EB-2 to EB-3 conversion is a downgrade conversion, is a new application. Is this something, a new concept? Have you ever done it? Do you ever know it, what it is before September 24th of 2020?
Yeah, it's actually not a new concept. We've been doing it over the years whenever, the visa bulletin between the two categories, one is more beneficial to the other. We actually went back and looked, and we've got YouTube videos from 2018, again in 2019, and then now just a month ago. So
yeah,
it's not
6 weeks ago, actually.
Yeah.
We presented on it, and we put a link on there. Those YouTube videos have been presented 2 years ago, 1 year ago, 2018, 2019, and in 2020, in the month of August, we predicted these. I would say we predicted it. In the past 2 years, the EB-3 has been advancing more for Indian nationals. So that was nothing new that came out in October visa bulletin. Now, at the same time though, when you go to the Chinese nationals, it's been there for a long time. EB-3 most often was more advanced than EB-2. I would say that I have done more EB-2 to EB-3 conversion, more to Chinese nationals, than that of the Indian nationals though. In the past 2 years, yes, there are some trickling in cases that were there. So if you look into the past visa bulletins, you can notice that. Now, Emily, is there anything in the law that says that you can downgrade for I-140?
There's not any specific provision of the law called downgrade or that says downgrade is a thing, but it's possible. I mean, it's just filing an I-140 petition, and the law says that as long as the labor certification was filed with a previous I-140 while it was valid, you can file another I-140 using that same labor certification, even though it's expired. So I guess that would be the law that allows you to file a second I-140. But other than that, and I know a lot of the common questions I've been getting are, what happens to the EB-2 I-140? Does it go away? Do you still have it?
Everybody is calling it a downgrade, but it's not a downgrade, guys. You have one iPad, and now you're going to have another iPad. So this is EB-2, this is EB-3. This is not downgrade, okay? You have two. You can use either of those things. Now, when can you not use EB-2 though? Is when you actually get married to EB-3. You can't have two wives at the same time. So what is marriage to EB-3 means? Filing an adjustment of status is actually not a marriage to EB-3. The marriage is when you use the advance parole or EAD approval that came with this one, then you are married to EB-3. At that point of time, if you want to revert back to EB-2, it is a very lengthy and very strenuous process. But if you file an adjustment of status in the downgrade right now, and you don't use the EAD, and you don't use the advance parole, and you want to go back to EB-2, absolutely you can go back to EB-2. What did you lose by going back to EB-2? Well, of course, the money that you spent on filing the adjustment of status, the downgrading of I-140, you lose that thing. Absolutely, you lose that thing. Now, the question now, if for general public is, do I downgrade, do I don't downgrade it?
That is the question of the last, ever since the visa bulletin came out, I think.
Now, here is the thing. To tell you whether you can downgrade or not, we must be experts in evaluating that, how the visa bulletin moves. And I claim to be, on this entire planet, the only person in the entire planet that has predicted the visa bulletin so many times wrong. Nobody else is there in this planet except me. And if somebody wants to prove that they can beat me in my this bad thing that I did, well, they have to prove it. You can go back to last week session, we're having a debate between me and Emily. I predicted the visa bulletin will move to 2011. You said, Emily, 2012. We both were off. You were off by 3 years, I was off by 4 years. So it's very tough to predict the visa bulletin. So that's where this, when people are asking the choices, what should we do? We can only tell what is good, what is not good. We can't tell, okay, do this one. The reason is that if we tell to do this one and they get married to EB-3, then they will come and whine, Rahul Reddy told to marry to EB-3. Now I can't go back to EB-2. That's one thing. The second thing is that, I mean, it's if you don't get married, you just file the adjustment of status, and then you want to go to EB-2 later on, then you can tell me, hey, you told me to spend all that money only to not use the EB-3 at all. Could it be? So it's a very tough choice, though. I'm an immigrant. I got my green card in May of 1996, in the last millennium, not this millennium. I'm a very old guy. Now, when I got my visa, which is on May 18th of 1996, I remember the day. By the time the visa bulletin already came for June of 1996, it went back. So the openings that come out in the visa bulletin comes very rarely. After that, my friend who was about to be interviewed the next month had to wait for 4 to 5 years for him to get the green card. It was in EB-3 at that time. I was a dependent. Now the openings then came in 2000, and then the opening came in 2007. Then the opening came in 2012, a little bit of it. In 2015, there was a flirting, there was never opening. It was a cheating by the USCIS. So it was 1996, it was 2000, 2007, 2012, and now we are in 2020. The opening comes in. When the opening comes in, will it remain open for a long period of time? Will it remain open for 2 months, 3 months? Will it remain only for 1 month? Nobody knows. In 1996, it was open all the way. It closed in 1996 June. Then it closed for a while. It opened up in 2000. In 2007, it was only open for 1 month. Only 1 month. There were some technical rules why they extended it by 1 month and 16 days. In 2012, though, it opened up for a while. It was there for about 3 to 4 months, and then it closed. I would say about 4 to 5 months. It closed. So now this opening in October, can we tell that if it's going to open in November, continue open in November? Will it open in December? We cannot tell. Absolutely we cannot tell. I mean, if there is any person who tells it, the best person that I think about is that, you know, the parrot guy that roams around in India with the parrot and all those things, he will tell you your luck. He would be much better than this lady sitting next to me. The parrot will be much better because I know her. She predicted so many times wrong. Emily, did you?
Oh, absolutely. Wrong every time. It's just impossible. One of the questions I'm getting a lot is, you know, how do you avoid getting married to your EB-3? Mm-hmm. I thought once you filed the adjustment of status, that your adjustment of status, you can't keep extending the H-1. Is that true?
Not true at all. You can still extend the adjustment of status. You can still the H-1B because your priority date is final action date is not current. You absolutely have no problem extending the H-1Bs at all. Even if the final action, you can keep on extending the H-1Bs. As long as you don't use the EAD and advance parole, you are not married to EB-3.
So just getting the EAD approval in my hand is okay?
Right.
What would cause me to use it? What does that mean?
Let's say, for example, you're working with company A on H-1B. Now you want to move to company B, and the company B doesn't file an H-1B. That means you're getting married because you're using the EAD card. Now, even if you move to the company B though, Emily, the company B can file a 485J supplement. Still you're not married because you still did not use the EAD if they get the H-1B. Just because they did the 485J supplement doesn't mean that you're married. But once you use the EAD, that's one thing. The second thing is that if you are traveling to India and you don't have a visa, and you're using the advance parole that comes with the EAD, and you're coming back into the country, that will be considered as getting married to the EB-3.
All right, I want to ask about some different scenarios that keep coming up, you know, to determine is it safe to downgrade or not. So the situation is I have, you know, an EB-2 approval from a couple of years ago with the employer I'm working for now. I'm still working for the company on H-1B, and the company is willing to downgrade. How safe is that for me to downgrade?
Working for the same company. Typically, if the person is working for the same company, the downgrade is naturally safe, Emily. One thing is that in the EB-2 category, what we got certified in the normal language to tell is that this person has the capability of climbing 100 floors in 1 hour. That's EB-2. Now when it comes to the EB-3, all we are telling is this person has the capability of climbing 75 floors in 1 hour. That's all. So there are some financial things that need to do. If by any chance the prevailing wage is, let's say for example, $80,000, you're getting $60,000, depending on the company financials, there may be some slight issues that they need to consider. But if they're getting over and above the prevailing wage though, I'm not expecting any trouble, do you?
No, I agree with you.
Okay.
What if my EB-2 approval is with my old employer, my new employer has not started the perm yet? How safe is it to ask my old employer to do the downgrade and file the adjustment with the old employer?
There are, you can definitely do it, but there are some risks associated with it. It depends on the finances of the company that is going to actually file your downgrade application though. The reason the finances come here more important is that, let's say if your prevailing wage is $80,000, you left the company in 2017 December. You did not work for the company in 2017, you did not work for the company in 2018, you did not work for the company in 2020. So now the company has to show that you have, the company has the capacity to pay the salary for you in 2017, 2018, and 2019. Doesn't have to show in 2015 and 16 because they already paid you in 2015 and 16. Now in 2017 and 18, if the $80,000, they didn't pay you because you never worked for the company, so they have to have a financial assets or they must have a profit that balances your $80,000. What if they're filing for 10 people? Well, then it multiplies at that point of time. So those things the employers have to carefully consider if they have the capacity to substantiate the ability to pay for the I-140. So these things the employers have to discuss with their lawyer to make sure everything is okay.
All right, I have a somewhat non-downgrade question or potential. How about I have an EB-3 approval with my old employer and I have an EB-2 approval with my new employer? Should I downgrade with my current employer or just file the adjustment with my old employer?
I feel more safe in downgrading with the current employer rather than actually moving to the old employer, Emily. Because the ability to pay is not an issue here. Because you left the company, ability to pay issue can pop up even if the person has not withdrawn the I-140, things may pop up. There is a little bit of issue when you left the company, when you're filing an adjustment of status with that. The reason is that the purpose for which you are entitled to get, you're eligible to get the green card is you have a job offer with the old company. You left the company or they let you go. Now, if the job offer does not exist because they let you go, you left, then there is issue comes in, is the job opportunity still continues to be in there? Now we've been successful in making an argument, yeah, he left the company, but he wanted to go learn something more and come back and work for us. As such, we don't have to do a lot of those arguments, we never got any denial, but there is a potential possibility that the immigration can ask the question. That's the reason I feel that I am more inclined to downgrade with the existing employer compared to going to the old employer. Do you have a different opinion?
No, I agree with you. Another question that comes up is, so if we file the downgrade and we file the adjustment of status, and then you're telling maybe it's not a good idea to get married to EB-3, so I should continue to maintain my H-1. What benefit am I getting by filing this downgrade and adjustment of status if I still can't use my EAD or advanced parole?
Good question, Emily. What happens, I told you, is that the opening of 1996, some of the people might not have been born, some of these clients, the opening of 2000, the opening of 2007, the opening of 2012. If you look at 96, 2000, 2007, 2012, 2020, those opening comes very rare, once in 5 years or once in a decade. What if they don't file it, and now the numbers backlog? Can the numbers go back? Yes, they go back all the time, many times, every time. How many times have you seen people going back? It happens. When it happens, you will be out of luck. You want to get in? No, the boat already left. You can't get in the boat. So the boat is there. You can keep one leg on the boat, one leg on the earth right now. You can do so. But once you get married, your both legs are on the boat. But if you lose the boat, though, you never know when they get. Now, can we assure that the boat is going to leave on October 31st? Absolutely not. We cannot. We cannot predict when the boat is going to leave. But for sure, at the visa bulletin, the boat is going to be there until October 31st.
So what if, I have a child who's no longer a child and is about to turn 21, and my filing date is current, and I file the adjustment of status for myself and my family and my kids? Does that benefit my kids at all? Are they going to be able to get the green card?
The Child Protective State Act is a little bit complex for people to understand it. Now, the kid, if they are turned 21, they don't become part of the parent's application anymore. Two things will kick them out: marriage and becoming 21 will kick the applicant out. There are some things for them to save it. One is that the time period for which the I-140 is pending, not the priority date, the I-140. That means when you file an I-140, until the time I-140 is approved, that time will be deducted from the kid's age. So that's one thing I want you to remember. Now the second thing is that I told you that they will be kicked out, marriage and 21. Once the adjustment of status is being filed, if the final action dates, not the filing dates, if the final action dates are current though, then the kid age is frozen. Okay? But in this case, Emily, the kid's age is not getting frozen because it's only the filing dates, not the final action dates. So the kid's age is not frozen. I want kids to maintain their independent status, either the H4 or in cases F1, until the final action date becomes current. What I advise people is that if the kid is about to become 21, if I were, I would file them the application and then try to see how my luck goes later on.
All right. Now, oh shoot, I forgot what my question was. Someone had just asked it about, is it necessary then, if we're saying don't use the EAD, don't use the AP, stay on the H-1B, should they file the EAD and AP at all?
First is, I did not set that don't use the EAD, don't use the AP, Emily, because there is some misconception in the people that EB-3 is better than EB-2. However, if you look into the Chinese history, I don't look into that. I mean, Chinese visa number history. And if you look into the past 2-3 years, it doesn't look into it. I think so. A lot of people are on the fear of that losing the EB-2 things. That's the reason I want to preserve it, okay? Not that, I think so they should evaluate after this fiasco is over, file it and evaluate it, whether they want to use the EAD and advance parole or not. Yeah, should they file the EAD and advance parole? Yeah, that should be evaluated too. Is it because if you're not going to use it, do you need to file it? Previously, though, Emily, we used to file advance parole and EAD because it was free. Right now, they're charging a lot of money. So I think so what I recommend people is to evaluate if you really want to file a 765, if you really want to file an I-131, I want you to evaluate. You just file the application right now, and somewhere in November, December, you'll have a free time, cool mind will come in, the rush will go at that point of time, and then they can evaluate they should file an EAD and AP as well.
All right, and then with the filing dates being current but not the final action date, how long will that EAD and AP be valid for if we file it now?
If you file it right now or a month afterwards, though, typically the immigration gives an EAD and advance parole approval. Previously, they used to go for 2 years. There is a chance that they may grant it for only 1 year. That's one thing. However, the good part of the EAD in this employment authorization is that once you get an EAD, when you want to get an extension of the EAD, you can file an extension of an EAD, and even if the EAD is not approved, you can work for a period of 180 days. Now please, H4 EAD guys, don't get any idea what I said. This is only for the extension of the EAD for the adjustment of status. Now, there are a lot of questions on the birth certificates that are coming in. In this panic mode, I don't want you to guys, panic a lot on the birth certificate. No, I have nobody else. I have not seen any case that got denied because of the birth certificate. First thing is, if you don't have a birth certificate, one easy thing is, I want you to get 2 affidavits. We have put that on rnlawgroup.com, go to birth affidavit. Now, there is a lot of things that I requested people to get it, but at this point of time, to get your day from this October, just get 2 affidavits. Where should I get the affidavits? You can get it from India, you can get it from here too. You can go to I know that you go to social gatherings, maybe not in the COVID period, your family friends, you just go have some beers or some grilling or something like that. They can give you affidavit and you can give it to them. You know they are born, you know their parents, they know your parents, you both can give each other affidavit. That's an easy way of doing it. You can get it from India too, if you get, but either of those things require notarization.
Ready for some questions?
Well, I want to, yeah. And the other thing is that if your name is missing in the birth certificate, I want you to get the notarization. If your mom's full name or dad's full name is not there, it's not a problem. Go ahead, Emily.
All right. Shrishti from Facebook notices that on the I-485 form on the website is only valid until October 31st and wants to know, is it okay to still use that even if the application is going to be adjudicated after October 31st? Yes, it is fine to use that. That's for filing the application, those dates. We do expect a new 485 form to be coming out, but we don't have any idea of when yet. It might not even be by October 31st, but you can use that. I will want to point out there's a new I-765 form coming on October 2nd, and they just posted that yesterday. So if you are planning on filing your I-765, that's for the EAD application, make sure the correct version of the form is being used. That form was just updated in August, and now they're updating it again October 2nd.
Rishi Chandan has this question. I don't like Rishi at all, but he brings an important point though. Can the priority dates be pushed back right now before October 1st?
It's happened. It happened in 2015, 5 years ago. We prepared all these applications for filing, and on the last
Only 2015
day, no, it happened in 2007 too. In 2007, they had to come back and change their mind and reopen it, but 2015 was awful. We prepared everything. There was a big lawsuit filed. USCIS dug their heels in. They would not accept those dates, and that was the first time we had the dual visa bulletin with the filing date and final action date.
Rishi, it happens, so you have to be watchful. Hopefully, you're wrong.
Nisha from Facebook wants to know, what if the child gets the EAD using the pending 485 of the parent, and then they turn 21. What options are available to them? Can they stay with that EAD until the parents get the green card? So the child, if they're under 21 now and they're filing with the parent, they will be eligible for an EAD. They get that as long as the 485 is pending, and they can keep renewing that EAD. At some point, USCIS is going to realize that they've aged out if the final action date has still not become current, and at some point they can deny the 485. So if the child has failed to maintain the underlying status, meaning they got married to the pending adjustment of status, and that 485 gets denied, they're immediately out of status, immediately unlawfully present, and USCIS can put them into deportation proceedings within 30 days if they don't exit the country. So that's a big risk to take. So the child who's in that age-out situation and trying to take advantage of the Child Status Protection Act should continue to maintain H4 status and then convert to F1 status and keep maintaining that until we know when the final action date becomes current.
Balaraju has this question from Facebook. Are medicals necessary in filing the 485 application? Absolutely not. It's not necessary right now. You can always supplement them later on. Raven Law has this question. What are you speaking about retrogression? Are you speaking about dates of filing or final action? Well, in 2015, it was actually the dates of filing that retrogressed. In 2007, there was no dates of filing. It was only dates, final action date. So both can retrogress. Crazy administration. They both can retrogress.
Gia from YouTube has an EAD card from Employment Based and wants to know, does that allow a side hustle, like selling things online, in addition to the current job? So that's where we're talking about the potential for marrying your category. So if you do have your H-1B status and then you use the EAD to start a side hustle, you're no longer in H-1 status. So that kind of limits your opportunities in the future if you later go and need to apply for EB-2. So doing a side hustle using that EAD eliminates your H-1 status. Now you're just in adjustment of status and need to continue to maintain that.
Question that was asked is that one of the employer is not filing an EAD. Can I file the EAD once I get the receipt notice, or do I have to go with the employer? You can file it by yourself, EAD. Once you get the receipt notice of the 485, which you're entitled to, you can file an EAD and advance parole by yourself. You don't need to go with the employer. Follow-up question is that, what if the dates retrogress? Can I still file the EAD once my adjustment of status is pending? Yes, you can. The question is, the adjustment of status application has to be in there. Once it's in there, you can keep on extending the EAD application. I have done for some of the people for a period of almost 10 years. Yes, it can be done.
Santosh from Facebook wants to know, if most of the people are doing this downgrade, the next month, could the EB-3 dates go back? Or will it impact after a few months? So yes, the EB-3 downgrades, because we don't know how many are going to be there. Right now, the current visa bulletin suggests that EB-3 should be moving forward rapidly. However, if there are a lot of downgrades, the EB-3 final action date may move forward much more slowly and could potentially retrogress. Now, the filing dates, they too could retrogress, but more likely USCIS will simply say, you can't use the filing dates after October 31st. Then we're stuck with the final action date, so that way they eliminate more people from filing into November.
Sandeep Kancharla from Facebook asks, can we wait until the November visa bulletin to file the 485? You could potentially do that. That option is there. Definitely in our office, we're giving more importance to the people who are filing the adjustment of status without downgrading. Because downgrading is the second preference, and maybe they'll change their mind in the downgrading. That's up to them, because especially if the visa bulletin in November moves forward for EB-2, then you don't have to do downgrading.
Andy from YouTube wants to know, what is the last date to file the adjustment of status under the October 2020 visa bulletin. Well, your applications need to be received, timely filed by USCIS by October 31st. However, that's a Saturday. USCIS does not collect the mail on Saturday. If your case is delivered on Saturday, it will be treated as if it was received on Monday, and it will be too late. So that means October 29th is the last day you can overnight an application for being received on Friday.
Vivek Nath from Facebook has this question. Do we need a non-availability birth certificate or just an affidavit is good? You need non-availability, but Vivek Nath, I know how difficult it is for you to get a non-availability. I'm a lawyer in India, don't forget that. So that's the reason you can file the adjustment status right now. And they may ask you to get a non-availability certificate at a later date, or there are other documents other than non-availability certificate. Also, when you go to RN Law Group and search with birth affidavit, you get all those things. But for now, Vivekananda, I suggest that, having done adjustment of status for 25 years, I have even attended adjustment of status interview only, even before I got my green card approved. I was an EAD and I attended the interview, and the client who asked me, when did you get the green card? I never answered that question to the client because I never wanted to tell my client I don't have a green card. So I've been doing that from past 26 years. So you just file with the affidavits right now, and then you can later on deal with it. It's very bureaucratic, especially with the COVID situation. It's very tough for you to get the non-availability. But if you can get it, that's fine with me.
Shiva from YouTube wants to know what information is needed for the new I-944 form under the public charge. This is the Declaration of Self-Sufficiency, which does have to be filed by each person filing an adjustment of status. This is my least favorite form of all time. It is the bane of my existence. I do not like this form. You need a credit score.
What if the kid is 10-year-old and doesn't have a social security number?
All right, well, the credit score, you can say, I just handwrite child on there. You don't have to give it for people who don't actually have it, but if you have one, you have to provide your credit score, you have to provide your credit report, you have to provide your most recent tax return, you have to provide proof of all of your assets. That would be a bank statement, your retirement account statement, 529 plan statements, anything you have worldwide that you want to be counted, you can put that in there. You also have to put your liabilities. So then you have to have a credit card statement, assuming you have debt on a credit card. You have to put your mortgage statement, student loans, anything else like that. Car loans need to be put on there. And then you have to provide health insurance proof, and then not for the main applicant because you have an I-140, but for your dependents, you have to list what their education is. So if you're your spouse who's filing with you, you need to mention what their education. You don't have to document it. I normally don't submit the documentation of that. But the 944 package by itself is literally this thick for each person. It is the worst form ever created.
How many pages is it in?
The form itself is 18 pages. The 485 form is 20 pages. But it is just such a waste of time for employment-based applicants. You're getting your green card because you're getting paid, you're getting a job. You surely can support yourself and your family, otherwise you wouldn't be here filing a green card based on that. So it is just a waste of time, but you have to do it. Make sure there's not any missing boxes checked. The 485 form is super confusing about which boxes to check based on whether you need to submit an I-864 or an I-944 or all these, in one wrong box missed and the whole thing gets rejected. Rejections may not come until November, and by that point you may have missed the boat. It's going to be a mess.
Emily, is there a requirement for a 944? Can we file without a 944? Is that a court judgment that says that you don't have to file the 944?
Court judgment was blocked, so now you have to include it. And even if you're in one of the two states where I think there's an injunction still, just file it. If you are employment-based category, there's no harm in filing it, but there's a lot of harm that could come if you leave it out and USCIS decides it's needed.
Questions are coming. Can I use my advance parole even if advance parole and go outside the country and come back and then come and use the H-1B? No. Once you use advance parole, your H-1B dies. So practically the effect will go off. Another question, do I need to get a credit report from all 3 bureaus? No, you don't need it. You only need from one. What I strongly recommend, well, you know, I may get some commission from them, just joking, is Credit Karma. It's free. You go there, you get it from two agencies. You get it if you enroll in it. It's free. I myself go and check myself, so it's free. I strongly recommend creditkarma.com.
Very common question I'm getting right now for physical therapists. Chaitanya, I think, brought this up.
Yes.
Can you downgrade for Schedule A?
They don't have a labor certification.
We don't have clear guidance on this.
But one question that I have, Emily, is that especially when you file for Schedule A, you need to post the notice and all those things. You have to do it again. That's my problem. Because for the EB-3 to EB-2 to EB-3, it's already done. So you're just doing the labor certification. There's no labor certification for Schedule A. I have a problem with it.
Mm-hmm. Well, you do actually submit the labor certification. It's pre-certified, so that's
Right.
the argument I would make.
But for pre-certification, you still need to post the things and do certain activities, right?
Yeah, so I would suggest that once the I-140 has been filed, now the labor is considered certified.
Okay.
And that's the argument I'm going to be making. But we don't have any clarity on that. So if you're going to try it, understand that there is a chance that it could ultimately be denied. There are also issues, a lot of things are happening with education for physical therapists. It used to be that only a bachelor's was required in most states. Then all of a sudden it's the master's. Now it's the DPT you have to have, and you have to have the visa screen certificate. There are a lot of technical issues. So if you're EB-2 Schedule A said that your job required a bachelor's degree plus 5 years of experience. Is that now going to qualify for Schedule A when a DPT, a doctorate, is required? There have been issues with that for sure. So you have to be real careful on this. Understand going in that there is a chance of denial. So be sure to continue to maintain your current immigration status if you want to risk it.
A lot of questions are coming and predicting the priority date, guys. Please don't ask us. The best thing is there's a guy in the Parrot. You go to New Delhi, he's right in front of the railway station. He's much better than this girl and I am.
A lot of questions we've been getting about the interplay between H-1 extension and filing the adjustment of status. I forget who asked this, but if your H-1 is expiring early next year, say, and you're planning on doing this whole downgrade process and file the 485, or maybe your actual EB-2 priority date is current, totally not an issue that you also need to extend your H-1B. You can file the adjustment of status if you're in H-1B status now, and then file your H-1B extension as you normally would. If your final action date is not current, you can still get a 3-year H-1 extension. If your final action date is current when you're filing your H-1 extension, then you'll only get a 1-year extension because it's assumed that you'll receive your green card by the end of that year.
Rakesh has this interesting question. Can I-140 downgrade be done in premium? It can be done in premium, there's no doubt, Rakesh. However, though, I strongly recommend you do not do premium processing. Right now, file under regular processing. Once you get the receipt notice, you convert that into premium processing. I've done that several times, I don't have a problem. Why do I recommend not filing the premium processing? One reason. When they don't see the original labor certification, though, they sometimes get into a little bit frenzy mode, and then they will deny the entire thing and send the whole package to us. And then, as Emily was pointing out, if something is wrong, they send the entire package back, and you get the package in November, your priority date's backlogged, you're screwed up. That's the reason why I recommend that you file in regular processing. The day you get the receipt notice, you convert into premium processing. That's so simple. Yes, there are some issues on the premium processing to an extent too. Are all the premium processings were being adjudicated on time, or there some issues? Previously, about 3 to 4 years ago, when we used to do premium processing from like the same way what we did from EB-2 to EB-3, the USCIS used to say that you don't have the original labor certification, and they used to deny the premium processing request, and they used to pay us the money back. Nowadays, though, Their system has got a little bit better right now. I haven't got any premium processing rejection at all, Emily. So it is recommended that I want you to file in regular, convert into premium processing later on.
How long do you wait to convert to premium? I usually tell people to wait 2 months at least.
Well, I normally tell immediately, and I
Okay.
have no problem with it.
Yeah, I've had a number that they reject the 907 because they haven't been able to pull out the labor certification from the other file yet. That might take time.
Recently, their technology got a little bit better. Previously, it was a long period of time. Now it's got a lot better. One thing is for sure, if you don't do premium processing, it may take almost 2 years for you to get the whole thing out. That's what we noticed if you don't file in premium processing. It may take a long time, especially when you're downgrading.
Abhijit from YouTube wants to know what happens if the work location has changed from where the labor certification and I-140 were approved. Can you still do the downgrades? Can you still file the 485? So if that work location is no longer a valid job offer for you, unfortunately that labor certification is of no use. The labor certification is only valid for the work location specified in the labor approval and where the labor market was tested. So if that work location is no longer available, a new perm, new I-140 is going to be required.
Question, can my wife who is in India be added to the 485 application? No. To file the 485 application, she has to be in the country. Question from Saurabh, what happens to my I-140 if I get added to my wife's I-485 as dependent? Your I-140 is active, no problem. However, though, if you get married to the EB-3, or if you get married not with your wife, you're already married. I mean to say that if you get married to the 485 application, that means that if you start using the EAD and advanced parole, you will have, there is a very lengthy and very expensive process for you to file an adjustment of status through your EB-2. It's very impractical to do that.
Guru Nathan wanted to know why does the visa bulletin say the dates, final action dates should move forward rapidly? So obviously the final action dates didn't move forward much at all for the October visa bulletin compared to September. Now we do know that we have a large number of family-based green cards that are being spilled over from last year to this year's employment-based. So that does allow the final action dates to move forward more swiftly, but they can only take a case, an application, when a green card is immediately available, meaning within the next 8 to 12 months, the final action date will be current. So they don't want to move those final action dates forward too far, and then they get in all of these applications and a green card is not actually available for those people. So they have to use the filing dates to allow people to file, figure out how many people are actually in the pipeline, because they honestly have no idea how many people are in the pipeline, because everybody's got more than one I-140, everybody's got family, you don't know how many family members are going to be filing. So it's that influx of family-based cases that, or family-based green cards, that should allow the dates to move forward more rapidly. But when we have these downgrades to EB-3, EB-3 might actually move more slowly than anticipated, and then EB-2 starts moving more rapidly, and then they flip-flop and they keep going back and forth. They may even out at some point.
Can I switch back to EB-2? This question comes from Sharma Neha from Facebook. The main issue, Sharma, is that, Neha, is that, are you married to EB-3? That's the main question that pops up. And please go back to our first thing. Marriage to EB-3 means you use the EAD and advanced parole. If you're not married, though, your EB-2 is still active, you have no problem. You can still file an adjustment of status on EB-2. You may have to refile the entire adjustment of status. That's the cost thing. But you can do so as long as you don't get married to EB-3.
Vivek from Facebook has an old EB-3 with an old employer and is getting ready to file perm with the new employer and wants to know if the perm should be filed in EB-2 or EB-3 with all of this craziness going on right now. It's a very good question, getting it a lot right now. So the good news is the perm, you don't specify the category on the perm. The perm, you just set out, these are the education and experience requirements for the job. So you don't have to make that decision until your perm is approved and it's time to file the I-140. Now that being said, A perm that is prepared for the EB-2 category can be filed at I-140 in EB-2 or EB-3. However, if the perm is prepared for the EB-3 category, meaning the education required is less than a master's degree or bachelor's plus 5, then you're in the EB-3 category. Then you do not have the option of filing that I-140 in EB-2. So if you have the choice, your perm should be filed with a job that requires at least a bachelor's degree plus 5 years of experience or at least a master's degree. And then once that perm is approved, look at the dates and figure out which one's better. You have the option of either. You could even file 2 I-140s at the same time, one in each category.
Questions are coming out. Shista from YouTube has a question. If I miss this deadline, what are my options? Well, first thing, we don't know if this deadline might be extended until November 30th. It could be, who knows. If it's not extended, then as I told you, missed the boat. You have to wait for the boat to come back again. And we cannot predict when the boat is going to come back. Definitely not.
Arun wants to know if the supplement J is mandatory for filing the 485. Will USCIS reject it if it's filed without? Yes. If your I-140 is already approved, meaning you're not filing concurrently with the I-140 and the 485 together, the supplement J is mandatory and USCIS will reject the entire thing if you don't include the supplement J.
What if I am actually filing with the downgrading of the I-140 only? Do I still need the 485J supplement?
Nope.
The reason is that you're filing along with the I-140. You don't need to have a 485J supplement. But if you're filing a regular one, you need the 485J supplement.
Naveen from Facebook does a lot of international travel for work and wants to know, can he downgrade to EB-3 and apply for the EAD but not the AP, so he can continue to maintain H-1 status and travel only with the H-1 visa? Yes, that is an option. So when you're filing your 485, you have the choice whether to include the EAD or the AP or both. And one thing to mention is if you file the advanced parole and you end up having to travel while it's pending, USCIS current policy is to deny it because you left the country. So then you just wasted $500 and some odd with that advanced parole. So that might not be a bad idea for you.
Simi Kaur has this question. I have an I-140 approved under National Interest Waiver, which is also EB-2. Can I downgrade? Answer is no, you cannot downgrade it because it doesn't have a labor certification with it. So NIW is only, NIW is only for the people under EB-2. It cannot be done under EB-3. We researched it. We had a lot of people asking this question. So you can't downgrade it.
Deepak from YouTube wants to know, if I file the downgrade and then later EB-2 becomes current, can the employer withdraw the downgrade and then I file the adjustment under EB-2? I don't see anything in particularly wrong with that, as long as you're continuing to maintain the underlying status. But why withdraw the EB-3? Because then if EB-2 goes back again, if they don't adjudicate your case in time, now you've lost the EB-3, which you just did all of this work to get. So I don't see any reason to withdraw it.
Is it necessary for the dependents to file 944 and 864 while applying for 485? Priya, assuming that you're filing in the employment-based immigration, you need to file 944 for everybody. Even a 2-year-old kid has to file for 944. Now, with regards to the I-864, no, you don't need to file I-864 if you're filing for employment-based green card application. There are some exceptions available. 99.9% of the time, you don't have to file the I-864 application. There is something called I-134 application that we file for the dependents where the main applicant signs the I-134, but not I-864.
Ashwarya wants to know, is applying for the EAD and AP an additional step after filing the adjustment of status, the 485? It can be. You have the option. You can file the 485, the I-765, and the 131 all together in the month of October, Or you can file just the 485, and then once you have that receipt notice, you can file the EAD at any time based on the pending 485, or you can file the advanced parole at any time. So you have either option.
Sundar Rajkumar has, how do I correct my priority date in my I-140 approval and file my 485 application? Yeah, in fact, I just filed today one EB-1A case where it was supposed to be ported from 2011 to right now, but it didn't got ported though. All we do is that we include a sheet telling that it should have been ported, it was not ported, and we give the old I-140 approval and the new I-140 approval. We clearly mention them, and we clearly mention do not reject it until you take this to the supervisor. Then it will give an attention to them. So in your case, if the date is wrong, you can show the old I-140 approval, or in your case, it may not be old I-140 approval. It may be labor certification date which is not ported properly. I will give it, I'll put a color sheet, and this color sheet looks so ugly, believe me, that it gets attention of the people. They won't just dump it out, they normally take it to supervisor. Yes, even after putting that thing, there were some instances where they sent the whole package back to me. I have to refile it. It happens, but that's the only thing you can do right now.
Ashish from YouTube has 2 I-140s approved from the same employer. The first one's in EB-3 and the second one is in EB-2. Are both the EB-2 and the EB-3 valid? Well, assuming that the reason that you have the EB-2 approval is because the EB-3 job changed and that job is no longer available to you, only the EB-2 is valid, and you would have to downgrade, file the EB-2 downgrade to EB-3 in order to file the adjustment if your priority date is current right now. You would not be able to use that old EB-3 approval if that job's no longer available.
Nandan Shah has this question. If children are born here in USA and have a US passport, do we need to include them in the adjustment of status? Do we need to file their adjustment of status? You need to mention them that they are your kids and they're born here. In your 485 application, they ask you what's your dad's name, what's your mom's name, what's the date of birth of your mom, and they will ask you about your kids. Who are your kids? You need to mention them. Do you need to file an AOS for them? Absolutely not. That's the best thing that they have, is they don't have to deal with immigration lawyers like us. They are born here, they don't have to go through all the pain.
So Rob from YouTube wants to know what happens to my I-140 if I get added to my wife's 485 as a dependent. That I-140 remains valid, so if you have not gotten married to your wife's 485 by using the EAD or AP, if your I-140 priority date happens to be in better than hers later on, you can file the 485 again with you as the main applicant and her as your dependent. We see that happen quite often.
Emily, a discussion on all this thing seems to definitely springing from one thing, because the family immigration ban that's there, it still is ineffective in October, November, and December, the 3 months of the next year. And who knows, Trump might come again, okay? So what do you say? Employment-based immigration people should be happy?
I mean, yeah, because those will carry over next year. A year from now, we'll be talking about those 60,000 green cards that went wasted.
60 or 100,000.
Yeah, and if it gets extended, yeah, even more.
And most of the consulates were actually closed starting from March though, or April I would say. So the first 6 months of the year, which is October, November, December, January, February, March, the consulates were open, the green cards were being granted. So definitely if Trump comes in again, and which he does the ban again, yeah, the employment-based immigrant people might get more. I'm not a fan of Trump, but in this particular case, it's definitely benefiting the employment-based category. I will support the getting of the green cards to that. I don't like to harm other people, but I would like to get for the employment-based people.
Kirti wants to know, is there going to be a considerable delay in getting the EAD if I file my application at the beginning of the October versus the end? Or is that going to change? Is there any benefit to filing at the beginning of the October versus the end of October? There's not really a whole lot of benefit, and there's not really any difference because it's going to be a big mess. Just think of the H-1B lottery time prior to this year where we filed all those applications on April 1st through April 5th. It took them 3 months to go through them all and send us all the receipt notices and the rejection notices. So everybody who's filing in October, for the most part, whether it's the 1st or the 31st, you're all going to be in the same boat. And the processing time is really going to be based on when does your final action date actually become current and how busy is your local office where the interview happens, because some local offices are faster than others.
And we're not expecting much miracles also in the EAD if you file in the first of the month or the last of the month. Because it's going to be messy though, because we know it's messy. We all see that. So it will take a little bit time for them to sort out, to do the things. So I don't give much importance whether you file it in the second of the month or end of the month. There's a difference in first of the month though, Emily. I don't want to get into the detail of the first of the month, but anything filed after second of the month will go into the same category.
Cal from Facebook wants to know about interfiling. For interfiling, should we stay on H1? So that's a good point we want to make, that if we're talking about someone who's downgrading to taking advantage of EB-3 and later wanting to go to EB-2, that is not an interfile option. Interfile means you are adding something to the file that wasn't there at the time of filing, or your, like your medical exam, you're interfiling it to get them to add it to your file. Interfiling is not the same thing of what we're talking about if you're later going to EB-2, because to file the EB-2 case, you have to qualify for EB-2 at the time of filing. You can't just take the existing 485 and magically turn it from EB-3 to EB-2, because the EB-2 date was not current when you filed your 485 in October if you're doing this whole downgrade. So it's not an interfile. You do need to continue to maintain your underlying non-immigrant status, and then if EB-2 becomes current, file another 485. Not an interfile request, file a second 485.
Seven Singh has this good question, Emily. How long it's taking for an EAD and AP, especially with the downgrade application, what do you expect? I don't see any downgrade effect at all on the EAD and AP. Just the downgrade cases will not be treated any differently, Shivant Singh. What is good, right now it's taking about 10 months to adjudicate the EAD and AP applications if you file initially though. Now with addition of the COVID, remember that COVID came in March, it was not there in January. So with addition of COVID and with addition of all these applications that are getting filed right now in the employment based, I may expect a significant delay. I may even expect 12 months on the EADs and advanced paroles.
Yeah, they're already taking 8 months plus, and now you're going to add a huge number of people all filing in 1 month. It's going to not get any better because we still have budget issues with USCIS. Even though they didn't furlough those people, they did. There was no bill passed by the House and Senate that provided the funding needed that also required them to process things in a timely manner. Nothing has been done to address the bad processing times. They're only going to get worse.
A lot of issues on the birth certificate. The name is a little bit messed up. People are complaining. Please address that. Let me tell you one thing. I don't know whether I'm a victim of the name thing or I'm a benefit of the name thing. My name is not Rahul, guys. My name ended up to be Rahul. My family name is Rahul. My actual name is Venkat. So the way you write in India, especially in the South India, is different. So I ended up with Rahul. My actual name is Venkat. So it's not a big deal in you getting the green card. I mean, if they want to really interrogate you to see if you are the real person or not, they can. But overall, it doesn't cause much problem in you getting the green card, though. That should not be much problem because, and there is a column in the 485 application that asks you what are the other names used, please, include all the names, because they want to check if you are a terrorist or a bad guy using a different name and now you change the name or something like that. They just want to find out that information from you. So in there, all of the names used, put all the names you ever, even when you're a kid, your mom called you puppy, you can put that one too if you want to. That's up to you. So as long as you put the names and they check in the FBI and you're good, that's fine, you're good.
I think we're about out of time for today. I know we had a lot of questions.
Normally we tell people to consult us or take an appointment at this point of time. Please do not contact our office to take your cases. We are just only entertaining the clients that are our own clients. We are not taking any other clients, unfortunately, because it doesn't justify us to take other clients at this point of time. But hopefully in November we'll be free, and at that point of time we'll be able to take the cases.
All right, thank you for joining us. Good luck, everyone, with filing this October, and keep calm.
Yeah. Thank you.